you're an IP lawyer. The main distinguishment or the main confusion among people is the difference between trademark, copyright, and patent.
Yeah.
Can you please clarify it?
Absolutely. That's what I do for a bread and butter. That's what most of my time is spent on. Okay. So if you have created something which is like a brand name, let's say your brand is Barely Opinionated, right? The name or the logo of Barely Opinionated is something that you trademark. Why? Because it is your identifier. Okay. This is how your brand is known. This is how your business or product is known. So if you're selling a product, let's say Apple, the word Apple used for computers is a name, is the identity of the product, right?
Interesting.
So you got to trademark it.
So Apple is a great example that you're taking, because Apple is also a fruit. And
correct. So the law says that if you have a name which you are using, so the name that you have can be an invented word. It can be a name that has no meaning whatsoever. Like Google, I don't know what it means. I don't think Xerox has a meaning. There was a recent trademark client that we counseled. His brand was Flabuza. Flabuza for t-shirts didn't have any meaning. So that's one level of it. The other is if you take an existing dictionary word and apply it to something totally different. Is that okay or not okay? That's absolutely okay. So the law says that it should not be describing what the services are. So if you have a brand which is, let's say Boots Bazaar, or let's say the shoe shop. I recently saw somewhere the shoe shop. It's not okay because you're describing, or pretty much it's a generic brand name, right? There was a gym that I used to go to long time ago called The Gym. Obviously, I stopped going there, not for this purpose. But The Gym was a really bad example, like absolutely zero creativity involved, right? So those are not okay. But if you have a name like Apple, if you're applying it to a very different products or services, that's okay. So if you have a Rabbit, Rabbit is a brand for t-shirts, I think. That's okay. Because Rabbit doesn't really describe, it's not made of rabbit fur, or it's not like if you wear the t-shirt, you'll start hopping or something. It's not describing anything at all. It's basically a name that you want to use your products for, right? So that's still okay.
Got it.
So if you have a name, or if you have a logo, or if you have a slogan, or if you have, let's say, a color combination, that is a trademark. Okay, because it's a trademark. It's a mark used in your trade. Correct? So that's a trademark. Copyright is given for artistic works. It protects your literature. If, let's say, I write a poem on how to record the best podcast in the world. Now, that is something that I've created out of my own intellect. It's a literary work that I've created. Or let's say an artistic work. Let's say I draw a painting of you, right? Of you and me sitting together and how this whole thing works out. That painting is a subject matter of copyright. So artistic work, literary work, dramatic work, musical work, your songs, your music compositions, right? Your lyrics of a particular song, your cinematographic films, right? Your movies that you make, they are all subject matter of copyright protection. So that's copyrights. The third thing usually is patents. Patents are given for inventions, not discoveries. If you discovered that there is a star, no, that's not. I see a lot of people naming stars on their name, and cool, that's a cool thing to do, but you don't own the star, okay, because you've discovered something. If you create something, if you invent something, and if it is new, and let's say it's useful, and it's not very obvious also. It's not like you took the red wire in place of yellow wire and you fixed yellow wire in place of red wire. You just merely rearranging stuff. That's not an invention. But if you genuinely invented something like a flying car, okay, let's say a mobile phone, let's say a digital camera, a laptop. Back in the day, it was an invention, right? So those are things which you have invented. They were not existing anywhere in the world. Those are patentable. Then you can file a patent on it.
Got it.
So trademarks, copyrights, patents. There's also something known as designs. Designs is basically something which is aesthetic to the eye. So for example, if I have a bottle of water.
Wouldn't that fall under artistic work?
Yeah, but there is a separate category of intellectual property that protects design. So when I say design, I don't mean a 2D. What I mean is let's say a physical product.
A product design, a physical product.
Yeah, a product design. So let's say there is a water bottle, which is in the shape of, let's say, Qutub Minar. Okay, or like an Eiffel Tower. And you can twist the Qutub Minar ka top, and then that's how you drink. I'm not inventing the bottle. I'm just making the bottle look cool. Right? I was again, sorry for the candid example here, but I saw a pillow which was very provocative. and it felt like as if you're hugging a woman and sleeping, right? And your head is on her chest.
I think that's a great invention for lonely people.
Possible. That's a great product design. It's a pillow. You're not reinventing the concept of a pillow. You're just making it look wow. And obviously, I'm not sure if they're selling more. Maybe they will. but that's a design, right? So patents protects inventions. Copyrights protects artistic work, literary work, dramatic work, cinematographic films. Trademarks protects your brand names, your logos, your slogans, your color combination, even the sounds. I forgot to mention that. Even a particular sound, like your Britannia, ting, ting, ding.
Ooh.
Right? That's the minute you hear that sound, you're like, "Arey, ye Britannia." Or let's say Airtel. You remember back in the day there was a jingle.
Of course.
The Airtel jingle, right?
Of course.
So that can be protected as a trademark because it becomes an identifier with that particular business.
Got it.
You know, and last is the design that I just
spoke.